Britain may have to accept untold numbers of migrants from Gaza after a court ruling. The courts have been blasted for opening the floodgates to millions of refugees after a Palestinian family was granted the right to live in Britain through a scheme designed for Ukrainian refugees. The family of 6, a mother, father, and 4 children who were aged 18, 17, 8, and 7 in September, were left homeless after their house in Gaza was destroyed by an airstrike during the Israel-Hamas war. They applied to enter the UK under the Ukraine Family Scheme to join the father's brother, a British citizen who has lived in Britain since 2007, but their application was rejected in May last year after the Home Office ruled they did not meet the scheme's requirements. The family, who have been granted anonymity, appealed the decision, but their case was dismissed by a first-tier immigration tribunal judge in September. However, following a hearing in January, upper tribunal judges ruled in their favor on the grounds of Article 8 of the European Convention on Human Rights, which protects the right to family life. Judge Hugo Norton-Taylor ruled, "We conclude that the respondents' Home Office's refusal of the collective human rights claim does not, on the particular facts of these cases, strike a fair balance between the appellant's interests and those of the public." On a cumulative basis, the weight we attach to the considerations weighing on the appellant's side of the scales demonstrates a very strong claim indeed. Put another way, there are very compelling or exceptional circumstances. Accordingly, the appellant's appeals are allowed. The judge cited the exceptionally dangerous and dire security and humanitarian situation in Gaza, warning that the youngest children, now aged 7 and 9, were at a high risk of death or serious injury on a daily basis. He ruled that it was overwhelmingly in their best interests to be in a safer environment together with their parents and siblings. However, the Home Office warned that allowing the appeal could set a precedent for others, arguing that the absence of a specific resettlement scheme for Palestinians in Gaza was a significant factor and that granting the family entry would be a leap in Britain's immigration obligations. The ruling also referenced what the judge described as a floodgates argument, with the Home Office warning that an obligation to admit the family could lead to similar claims from those in other global conflicts. Reform UK MP for Great Yarmouth Rupert Lowe, posting on X, said, "Palestinian migrants claiming asylum must not be welcome to the UK." No ifs, no buts. It simply can't be allowed to happen. A Home Office spokesman told The Telegraph that the case had been contested rigorously and insisted, "The latter court ruled against us on the narrow facts of this specific case." Nevertheless, we are clear that there is no resettlement route from Gaza, and we will continue to contest any future claims that do not meet our rules. Quote,